State. Ms. Wolfstead, are you there? Can you hear me okay?
Yes, Your Honor.
We have several other folks on the phone. We have Pia Wallace with us from Anchorage. Ms. Wallace, can you hear me?
Yes, and I'm calling from Kodiak.
Kodiak, got it. We have Mr. Patterson's mother, Ms. Wyatt, on the phone. Ms. Wyatt, you're there?
Yes.
And we have Ms. Tinney, who is the victim in the stalking case. Ms. Tinney, can you hear me all right?
I sure can, yes.
All right. So the matter's on the calendar for sentencing this morning. I set these cases to be done by video conference, but for some reason, Lemon Creek did not put Mr. Patterson in the video room. I was told the room wasn't available, which I don't understand. I set these months ago. The statute requires fingerprinting to be done on record, and typically we need to do that over the phone, and I don't know how that can be accomplished over the typically we do that in the video room because there's an officer present. If Mr. Patterson's in an attorney room without an officer there, I'm not sure how we're going to do the fingerprinting, and I'm a little bit frustrated that the Polycom didn't happen. Mr. Miller, are you, I guess we could go forward telephonically and accomplish fingerprinting at another time, but it needs to be done on record. Mr. Miller?
I would defer to Mr. Patterson if he's all right with that.
I would prefer to move forward.
Ms. Wolfstead, are you state prepared to go forward with a telephonic?
Yes, Your Honor.
All right. We'll try to arrange for the Polycom fingerprinting to be done at another time as soon as we can get that available. Yep.
I guess I'll just note, I'm looking at the court calendar, and I'm not quite sure what else would be using the Polycom right now, since you're the only one with the hearing at 9 a.m.
I'm asking the clerk here.
Hey, Baron, is there some reason why I'm not in Polycom right now?
And then at the end, after sentencing,
Yes, I'm supposed to be in Polycom.
All right.
Well, I'm on the phone with everybody right now, and they're quite frustrated with the fact that I'm not in Polycom right now. Can't do that. Is there any way that we could switch that around, like ASAP?
Sounds like Mr. Patterson's talking to somebody there.
Well, sorry, I didn't realize I guess I'm on.
So apparently they need to fix something on speed here.
I'm supposed to be on Polycom. I was telling them that here, and they are none the wiser to why I'm not there either. So I was asking if I could be transferred to it, but nothing gets done very efficient here.
I know that. So I will have somebody call the jail and see. I mean, I don't particularly need the video connection. I mean, Ms. Patterson, no offense,
I don't either.
I'm happy to go forward, but we need to do the fingerprinting, and if we can get an officer to bring the fingerprint form in there and do it right there in the attorney room, that works for me. So, can we generate a fingerprint form, and then I'll see about getting my staff to scan it out there to the jail, and perhaps an officer can do it while we're still on record. Stand by a moment. I'm going to send an email to Keith. All right, so I sent an email. Hopefully we'll get that taken care of. All right, so let's move into the substance of things, and that'll hopefully take place while we're moving ahead. I did receive, and I read the pre-sentence report, a lot of attachments that were prior pre-sentence reports and other related materials. Officer Wallace, any corrections or additions to that?
No, Your Honor. There was also a dictum filed that had some criminal history information. That was filed on the 27th.
And I did receive that. Did counsel get that as well, Mr. Miller? Have you got that?
Yes, Your Honor.
Okay, good. Ms. Wolfstead, you saw that?
Certainly, Your Honor.
All right. Ms. Wolfstead, did you have any corrections or objections to the pre-sentence report? Or
I'll note that his presumptive term is 3 to 5, not 2 to 5, Judge, on 19-1290 at the bottom of the first page. And, well, I guess I'll wait for my next one.
Right.
Make sure there's no objection.
This is post July 8, 1919. Mr. Miller, I think that's right. Do you have any disagreement with that?
No, that's correct, Your Honor.
It's an HB 49 case. So, Officer Wallace, if I can get you to just change that 2 to a 3, he is presumptive 3 to 5 because this is under the new law.
Yes, Your Honor, will do.
All right.
And then,
sorry, go ahead.
I'm not sure if this matters. It says crime of domestic violence. Yes, that is true for 1JU 19-1290. That is not true for 9479. That was a theft from a store. I don't know if people feel the need to differentiate between those two. I just noticed that both of them are not crimes of domestic violence.
Right. I think the judgment certainly will make that clear, that 1479 is not obviously a domestic violence crime. Mr. Miller, if you want any clarification to that on the pre-sentence report, I'm fine doing that.
I think that, if I could just put a clarification on that part right there would be good.
We can just, after the yes, just, here's what I'll write on mine in parentheses, no as to 1JU 1479 CR. And Ms. Wallace, if you could also make that notation on there, that would be helpful.
Very well, thank you.
Right. Any other issues with the report, Mr. Miller?
Yeah,
Ms. Wolfstead?
I was going to say that Mr. Miller emailed me about something, and I remember agreeing with him, and I can't find the email.
Sure, Mr. Miller?
The issue is on page 6, Your Honor, which is what the agreement, or Rule 11 was. And the third bullet point under 1490 shouldn't be there.
So that was not a term of the agreement?
Yeah, that was not a term of the agreement. Ms. Wolfstead and I have spoken about that since, and she agrees that wasn't part of the agreement. The agreement is not contingent on any debriefing or testimony later.
All right, so I'll walk through that line. Ms. Wolfstead, you agree with that?
That is correct, and I will note that we agreed orally that that would not be part of the agreement, and I didn't even think about that when I forwarded the agreement to P.O. Wallace, so that is not her error, it is mine.
All right, so Ms. Wallace, if you could...
Okay.
If you could
I'm sorry, this is Stacy, and I feel so lost on your guys' agreement, on everything that's going on. If you guys could just re-update everything on what exactly is happening.
So, Ms. Tinney, the discussion that's taking place concerns a charge of theft at Foggy Mountain Shop, so it does not concern the charge that involves you.
Oh, okay. I'm like, thank you.
All right. And so, Ms. Wallace, if you would delete that third bullet point under 191490, as that was not a term of the agreement.
All right, very well, thank you.
And I want to clarify the agreement as I understood it. I want to clarify with counsel. The pre-sentence report states quite clearly as to 191290, the agreement, which is the stalking charge, that the agreement was that Mr. Patterson would receive a sentence of 5 years with 2 suspended, leaving 3 years to serve. Conditions of probation would be open to the court and the length of probation, but would include an order for no contact with Ms. Tinney. Mrs. Tinney could, if she wished to do so, come back later and ask to change that, but that is a term of the agreement and would be a term of the sentence.
Can I say
Ma'am?
something?
No, please don't interrupt me.
Okay, I'm sorry.
As to 1914-90, with a theft charge, the agreement was it was being reduced to theft in the third degree. There could be restitution and an amount to be determined. There would be a conviction of record, but there would not be any additional time for that. So my understanding is there would be no jail imposed, no suspended time imposed. There would be a conviction. There would have to be surcharges, but no other sentence other than the restitution. Is that an accurate summary, Ms. Wolfstead?
It is, Your Honor.
All right. And Mr. Miller, you agree with that?
Yes, Your Honor.
Right. Ms. Tinney, I'm going to give you a chance to be heard a little bit later on, but I want to work
Okay.
with lawyers. All right. Are there any other issues from either counsel about the pre-sentence report?
No, Your Honor.
All right. Ms. Wolfstead, did you wish to call any witnesses today?
I'm not going to call any witnesses. I do know Ms. Tinney would like to make a victim statement, but she doesn't need to be under oath for that, and I don't.
Sure.
She's not being called as a witness, just simply as a victim.
Mr. Miller, did you intend to call any witnesses today?
No, Your Honor.
Right. So the process that, just to outline it for everybody on the phone, that I'm going to go through is I'm going to give Ms. Wolfstead, prosecutor, a chance to make any comments she wishes to make. I will give Mr. Miller, counsel for Mr. Patterson, a chance to make any comments he wishes to make. I'll give Ms. Tinney a chance to make any comments she wants to make, and then I'll hear from Mr. Patterson if he wants to say anything. So that's the order that I'm going to go through things. Ms. Wolfstead, do you want to start us off?
Certainly, Your Honor. I'll also note Mr. Patterson's mom is on the phone. I don't know if she wants to say anything on his behalf. I wouldn't have an objection to that.
Okay.
So, Your Honor, I think this is an appropriate agreement, and I'm going to request that the court accept it. You know, this is one of those cases where you can see, especially when you look at the addendum, Your Honor, you can see through the history of this case, this is a genuine stalking event. Mr. Patterson engaged in an absolutely, in violation of multiple court orders, repeated acts of non-consensual contact with Ms. Tinney, culminating in this last case in which he located her. He was armed with a knife on his belt. He held onto her car. He wouldn't let her leave. He was then chased by Officer Payton into the woods, where he finally said, why can't I just talk to her? Why won't she just let me talk to her? And I'm not going to go through the addendum. The court's read it, counsel's read it, but it's, I think it shows over a period of months, a really, really significant course of non-consensual contact that existed here. I'm not going to talk, well, I'll just make an aside. I'm not going to talk too much about the theft case because it's a fairly common theft. He went into a local store, he stole a number of items with his co-defendants, and I believe at the behest of a third party. And I will just note that, you know, places like Foggy Mountain Shop are local businesses, and they have a hard enough time staying open to begin with. Theft makes that all the harder. But the real crux of this is the stalking, Judge. And, you know, I'm not sure how amenable Mr. Patterson is to rehabilitation. And I know he's made many comments before the court about how he can see clearly now that he's sober, and that he wants to stay sober. But here's the thing. Something that struck me so poignantly at the change of plea in this case, where Mr. Patterson had been sober and had been talking to the court about that, was his only question for the court at the change of plea was when he could talk to Ms. Tinney. And the answer to that is he can't. If she and when she does not want to see him, does not want to speak to him, When there are protection orders that she has requested from the court in place, the answer is he can't. And what has been really clear to me through this is that he feels that she has the right to talk to her when and where he wants, and it's on his terms. And that's not true. Ms. Tinney has the right to feel safe, to be safe from Mr. Patterson, and so even in his sober thinking, his first thoughts are about contacting her, and that's something that's very concerning to me. I think in a trial posture, I may have asked for more time significantly. However, I think what's important about this, and suspending time over Mr. Patterson's head is, and I just want to make sure we haven't lost the attorney for Mr. Patterson, because I keep hearing beeps on the phone.
Yeah, I keep hearing tones, and that's either someone joining the line or someone leaving the line. We do have a 9:30 on the calendar, and so we're running a tiny bit late, and maybe people are calling in a little bit early for the 9:30. Mr. Patterson, you're still there?
Yep.
All right. Go ahead.
All right, thank you.
Yeah.
So,
right now.
I think that the primary goals here are isolation, certainly, and individual deterrence. It's important for Mr. Patterson to know if he violates any of these conditions, including contact with Ms. Tinney, there's 2 years that can be imposed. And I will say that oftentimes the court gives people chances early on technical violations. I will note that if Mr. Patterson contacts Mr. Tinney, I will ask for all of his time. He needs to stop contacting her. He needs to allow her to be safe. I know that Ms. Tinney's position has changed throughout the life of this case. I know that something she, we talked initially at grand jury about how scared she was, Mr. Patterson, and about the course of conduct that has led up to that and the domestic violence in their relationship. But I also know that she does not harbor ill will towards him, that she wants him to get better. She wants him to get sober. She wants him to be a parent to his children. And she doesn't harbor, at least last I spoke to her, that ill will, but she also has the right to be safe. And so with those two as the primary sentencing goals, Your Honor, I do believe this is an appropriate agreement. I would request the court accept it. I think all of the conditions proposed by probation are appropriate. I think the court knows that normally I, as the state, come in and say, well, that general condition number 10 about the cars isn't applicable. I think it is here. I think C.O. Wallace outlined really well in the PSR what the nexus is, why it's important. And so I would request that the court impose all conditions.
Thank you, Ms. Wolfstead. Mr. Miller, do you want to make any comments?
Yes, Your Honor. To begin, on the day of the incident, Mr. Patterson wasn't out looking for Miss Tinney. He was brought somewhere with other people. It was a random meeting. He did have the protective order. He wasn't out seeking her, unfortunately. He did approach her, and what followed is in the report. I'd say that this incident and much of what else is in the PSR, Mr. Patterson's history is I think largely relates back to substance use, and Mr. Patterson is very aware of that and recognizes that is the biggest thing he needs to deal with. And he was having a period of sobriety and success for a while, a year and a half ago or so, last year, and then some things came up in his life, and that sort of unraveled, and he's aware that was his downfall, and he was working with our office on looking into treatment, and that is obviously a part of the conditions here, but he's very committed to that, and I think that he's going to be completing treatment as soon as he can and be taking it extremely seriously, and that's going to be key for him in the future. As far as the report, I agree with Ms. Wolfstead that this is an appropriate sentence here. I think our one issue is the length of probation. I think the report requests 4 years. We think that 3 years is he's already going to be serving 3 years. That's, I think, plenty of probation time would be, for this case, would be 3 years with Mr. Patterson being able to get himself together and prove that he's being successful in that time. I don't know the point of that extra year. But overall, Mr. Patterson has support. He has his family. His mother's on the phone. She's very supportive of him, and I think will be there for him as he works on his sobriety and coming back into the community and being successful. And we ask that you accept this agreement.
Thank you. Ms. Wyatt, I want to give you a chance if there's anything you want to say about your son. About the situation.
Well, I do. I have a lot to say, and it's, very upsetting to be in this situation with him again. He definitely has had substance abuse issues. And during his relationship with Stacy, that culminated really quickly and became an overwhelming part of their relationship. I've noted that through this whole thing that it's never really been addressed that while he did continue to violate the restraining order and have contact with her, although he wasn't stalking her, following her around, but he did pursue to have contact with her when he shouldn't. The court just kept kind of slapping his hand and telling him, "Don't do that," instead of saying, "You do this again, you're going to prison for 3 years." But he's an adult, and that's on him. But also, during this time leading up to the restraining order, I don't believe there's ever been any physical violence. I mean, he has never.
There hasn't.
Is there cases? I mean, for my relationship, knowing them and stuff, there's not that I know of. And in the actual restraining order, he had kept her from leaving the house. But even at that time in my conversation with her, he wasn't beating her up and he wasn't abusing her. They were both in a bad situation with drugs, and she was trying to get out of it, and he wanted them to stay a couple. And I get that his pursuit of her was wrong. But I know that he can, in fact, get clean and stay clean. And at the end of all of this, when he completes the program, our family's trying to relocate out to a farm in Montana, very rural. Part of our family's already there, and we would have already had joined them if Ian wasn't in this legal situation and not able to go with me and his son to go live out in the country where there's a good promise of him having a strong future with his family and finding a niche in life to be healthy and well. So as soon as he's able to leave Juneau, that is the plan. And so he won't be here in this community, and he won't be here where she is, which I'm sure she's going to carry on with her life, and he's going to carry on with his life. And I just want to get to that point with him, and he has a lot of strong family support that wants to help him get there. That will do this with him and for him to ensure a better future for him and us and his child.
Ms. Tinney, are there comments you want to make?
I do, yes. Okay, so he did get arrested, and she had said that Mr. Patterson had a knife on him. I was only making a point to the police officers that it wasn't in use for me because, he loves going out into the woods and just being part of, and I was just informing them that thank you. Please stand by. It was on his hip, but it's terrifying that it wasn't meant for me. He didn't have it in his hand. I'm sorry, I'm emotional right now. I care so much for Mr. Patterson. And in the very beginning, I got this restraining order to hopefully get him to wake up and not be
and sober up. The repeat of, for what she was saying, for the repeat of contact with me was, I only made it clearly through taking the notes and showing that he violated. I was only doing that just so I can, show the police officers that he is violated and he is violating, and they weren't doing anything about it. I forgot who the judge was that did the 20-day protective order, and he was pretty upset when the police officers weren't doing their job when I had showed them clearly pictures of. So, I mean, if they had done something in the very beginning with the 20-day protective order, he wouldn't have continued on contacting me and having the long-term domestic violence protective order. And what she was saying was, I really wanted to drop this protective order, the long-term protective order, but I was told by the aware shelter that if I go to drop this, that they will call OCS on me. So, I want to be able to know how he is doing, and I want to encourage him, and I love him, but this is the way that I was just scared that OCS is going to be put on me. So, I'm sorry, I'm crying because I get very emotional and I don't know how to let it out. Yes. Sorry. I just want the best. I just want the best for him. And in the very beginning of the 20-day protective order, I had requested for him to find some kind of treatment for him to be in. And the repeating of the contact and stuff, if the police officers did their job in the very beginning, it wouldn't have gone to the long term. And that's why I tried to get down to it, to where I just wanted Mr. Patterson to seek help. And it's documented saying that I just want him to get sober. Thank you.
Your Honor,
Yes?
this is Bailey Wolfson. I was kicked off the line for all of Mr. Patterson's mother's statement and most of Ms. Kinney's statement.
Oh, wow.
Sorry about that. There were a bunch of beeps, and I never know. I don't know if that's somebody joining or somebody leaving, and I didn't want to interrupt her to explore who it was. I was assuming it was people coming on for the 9:30s. Sorry about that.
No, so I don't know. I mean, I guess maybe after court, if somebody can just, because we're required to take notes on certain things, give me an overview of what, I figured I got what Ms. Kinney said, but what Mr. Patterson's mom said, what Ms. Wyatt said.
Sure.
I'd be happy to submit a statement of what I've said.
Sure, we can burn a CD for Ms. Wolfstead so that she can listen to it. Thank you, Ms. Kinney. Mr. Patterson, you have a right to say anything that you want to say before a sentence is imposed. Anything you want to say?
Yes. First off, I definitely apologize for taking up everybody's time, and, I do feel ashamed for this continual cycle that I find myself in. I got much important things I could be doing with my life. I have a son that looks up to me and that misses me every day, that I try to parent from a phone. You know, things spiraled out of control very, very quickly, and you know, I guess I didn't realize the severity of my actions. I feel like throughout this whole thing, my legal counsel has not done a good job of defending the fact that the DA has taken vast liberties of making me sound like I was a violent person in this relationship, because I wasn't. Miss Penny could attest to that. I've never hit her. It's not what this relationship was like. I guess I just didn't realize the severity of the what you guys call non-consensual contact, even though a lot of it was more consensual than the court will obviously know. I guess that at this point is neither here nor there, and I just look forward to getting this past me and getting out of this state and getting all of this away, as far away from me as I possibly can. Thanks for your guys' time.
I'm going to keep my comments pretty brief. There's a plea agreement that sets forth what the sentence is going to be, and I'm going to accept the plea agreement. Don't need to hold anybody in suspense about that. So I'm not going to go on at length. Start with this. Mr. Patterson's been getting in trouble pretty regularly, going back close to 20 years, virtually his entire adult life. I didn't count up the number of convictions, but there's a bunch, pretty much uninterrupted. Maybe uninterrupted isn't the right word. There are some breaks in it. I suspect those breaks, and Ms. Wyatt alluded to this, those breaks are periods of Mr. Patterson being sober or away from drugs for periods of time. And that's certainly the key to a lot of it. Not all of it. Some people get in trouble once and they say, I'm not going to do this again, and they don't ever get in trouble again. Some people get in trouble over and over and never stop. And, I have people come before me who are, senior citizens who have been getting in trouble their entire life and continue to do so, and it just kind of goes on and on. And everything in between. Sometimes people get to a point where they just kind of get tired of the revolving door of going to jail and getting out and going to jail again, and they make the changes that need to be made to their lives. Sometimes people do that through going to treatment, counseling, other kinds of rehabilitative programs, mental health treatment, whatever it might be. Other times people just kind of make that decision themselves, that I'm just done with this. I'm done with this life, and I'm going to live my life a different way. And I think ultimately that's probably what needs to happen for Mr. Patterson. You just get tired enough of this that you just do it differently. But I don't know. I don't know what it's going to take. I don't know if you're going to be one of those people who never makes the change, or whether it's going to happen this time. I hope it's this time. But I guess we'll see. Ultimately, though, every one of us is responsible for our own actions, and the things that have happened in the past when Mr. Patterson's gotten in trouble, the things that have happened this time are not, and I think I heard all of these set out at various times by various people, are not the fault of the police. They are not the fault of the judge who issued the domestic violence protective order. They are not the fault of Ms. Tinney. They are not the fault of Mr. Patterson's defense lawyer, and they are not the fault of the DA. And I think there was a reference to each one of those people in some way being at fault for what happened here. And I don't buy any of those things. Each one of us is responsible for our own actions. And when a judge, wasn't me, when a judge issued a court order that said stay away from Ms. Tinney, and Mr. Patterson didn't do that, that's not anybody's fault but his own. And, you know, it didn't just happen with this protective order. There are multiple prior convictions for violating protective orders, and multiple other kinds of crimes committed over and over repeatedly in various ways in the past. And as I said, every one of us is responsible for our own actions, and those are Mr. Patterson's actions, and they're what he's being sentenced for.
I do believe
ma'am,
that.
No.
Sorry.
No. We're not going to have interruptions. I'm pronouncing a sentence.
Okay, thank you. Sorry.
So I'm going to accept the plea agreement. I'm going to impose the agreed sentence. I want to say, I guess, one last thing, I'm sorry, before I just pronounce sentence, which is the theft case, 1914-79. There's no particular sentence being imposed in that case. I do want to say, although we don't have anybody from the store participating in this hearing, if that was a standalone case, there's a fairly substantial amount of merchandise taken from the store, and I don't want the business that those items were taken from to feel like nothing is happening and no one cares and no one's doing anything about it. If that was a standalone case, I would not accept an agreement that called for no sentence to be imposed for that charge. The law is pretty clear, though, that it's the composite sentence that the court's supposed to consider. And we have a composite sentence here that involves 3 years in jail and an additional 2 years of suspended time. And to me, it's all rolled into one thing, and I accept the agreement that calls for no time on that case because of that composite sentence. And so I don't want anyone who listens to this later to feel like no one cares about the theft from that store. I take theft seriously. I take those kind of crimes seriously, and I just wanted to emphasize that. So in 1914-79, for the reduced charge of theft in the third degree, I will impose a judgment that will not include any jail time, but it will include the mandatory surcharges, misdemeanor surcharge of $50. And there will be an order of restitution in an amount to be determined. Give the state 90 days to submit a proposed restitution judgment. If there is a dispute about that, I'd give the defense 30 days to request a restitution hearing. In 19-1290 CR, on the charge of stalking in the first degree in count one, I will impose a sentence of 5 years in jail. I will order the 2 years of that time is suspended. I am going to include in the judgment 4 years of probation. That does not mean that I think that there absolutely, ultimately will need to be 4 years of supervision, but I think that depending on how things unfold, I think that the judgment should provide for 4 years of probation. There is a provision in the law for reduction for earned compliance credits. There is the possibility of early termination. If Mr. Patterson pays the restitution ordered in 1914-79, he doesn't have any probation violations, he's clean and sober, if he complies with the orders about staying away from Ms. Tinney, then, I mean, I would be receptive to a request for early termination, but I guess I think that we'll have to see how that unfolds. But the judgment will call for 4 years probation. I will impose all of the conditions of probation recommended in the pre-sentence report with one exception, and I'm sorry, let me get to those. With the exception of additional recommended special condition number 8, which I think is the wording of that's the one that says you're not to knowingly associate with individuals who use or sell illegal controlled substances. I've never imposed that condition in any sentence I've ever imposed, to my recollection. I think it's overbroad, it's difficult to interpret, it's ambiguous in some of the definitions, doesn't define what associate means. It would, my view, prohibit Mr. Patterson, for example, from working in a place where another employee smoked marijuana in his residence, and I just think that that's overbroad and difficult, if not impossible, to enforce. So I'm not going to impose that one. I'm required to impose the $100 felony surcharge, the $200 felony surcharge under the new law, the $100 correctional facility surcharge, $100 suspended probation surcharge. I don't think there's any restitution at issue in the stalking charge. Ms. Wolfstead, do you disagree with that?
I do not expect that there is, Your Honor.
Right. Ms. Wolfstead, anything else you think we need to do on that chart? Well, we need to do fingerprinting. I was told that somebody would be bringing the fingerprint form in there. Has that happened, Mr. Patterson? Has anybody come there with a fingerprint form for you to do?
Hey, we got the fingerprint form in here. Did you guys see that email that I sent?
Yeah, it's supposed to happen on file, on record, while I'm on the phone.
Your Honor?
Yes.
I will just add, and I realized when you were making your sentencing comments that I failed to do this. I will add that I did speak to the manager of the store about the Rule 11 agreement, and that they were, because of the composite agreement, in favor of it. I forgot to put it in the position.
I appreciate that. While they do that, Mr. Miller, any questions about the sentence?
No, Your Honor.
Ms. Wallace, on your end?
All right, we're ready to proceed with fingerprinting on file.
Okay.
Off record.
Thank you. Why don't you go ahead and do it and let me know when you're done.
Okay, I will. Thank you.
Ms. Wolfstead?
Yes, Ms. Kinney?
I was wondering, how do I go about on dropping the long-term protective order?
I'll get you.
Is there a piece of form that I have to go to the court and fill out?
Yes, and I'll have a communication with you. I can call you right after this hearing is over.
Awesome.
Instead of having a
Thank you.
conversation on record. Can I get a good
Thank
number
you.
for you?
907-957-1750.
All right, as soon as we're done here, I'll give you a call, okay?
Thank you.
All right, fingerprinting is done.
Thank you. Appreciate it. Mr. Patterson, you're going to need to sign that, and we'll need the officer to sign that as a witness as well.
Done and done.
All right, good. And then I was told that Officer Ely be able to bring that back to the court at some point.
I'll give it to Ely.
Because he's in the, I believe it's
Yes,
officer. Well,
it'll be given to Ely.
thank you. I think he's in the Polycom room. All right. Anything further on Mr. Patterson's case? All right. Good luck, Mr. Patterson.
Thank you.
Thank you.
Case. All right, we're not on record yet. We're on record in the matter of State of Alaska versus Russell Schultz. I see Mr. Schultz on the Polycom room where he's been for a while. I don't know why they put Mr. Schultz in the Polycom room but not Mr. Patterson, but in any event, he's there. Who do we have on the telephone for Mr. Schultz?
Your Honor, Nick Pulaski. I noticed on the calendar that my name's not listed, but then I double-checked and I had submitted an entry of appearance. I've talked to Mr. Schultz and I'm ready to proceed. So
I have your entry as well.
Oh, good.
Your Honor, Peel Carlson in Anchorage also.
Thank you. Who do we have for the state?
This is Ms. Gibson.
Ms. Gibson is with us for the state. So, Mr. Schultz is on the calendar this morning for sentencing. There is a Rule 11 agreement I did receive, and I read the pre-sentence report. Let me just say, we had a sentencing at 9 o'clock with the Rule 11 agreement. We started a few minutes late, and then it took a lot longer than expected. Normally, a Rule 11 sentencing is 20 to 30 minutes. Mr. Schultz was scheduled at 9:30. I have a 10 o'clock teleconference with a bunch of medical providers about a family member that I cannot be late for. And that's 5 minutes from now. I don't think I can get Mr. Schultz sentenced, even though we have a Rule 11 in 5 minutes. I'm sorry. I know everybody's been waiting on this. The previous sentencing just went very long, and there were a lot of comments. But I just can't do it because I cannot be late for my 10 o'clock. Looking at my...
Your Honor, can I ask a question? This is Nick.
Yes.
I have a 10:30 bail hearing with you. Are you going to be around for that?
Yes, I anticipate being done by then. Might be a few minutes late, but I anticipate being done with that. I was going to suggest, I don't know if we could bump Mr. Schultz to 11 o'clock and try to do him after that Stubblefield hearing.
That's in part why I was asking, because I'm going to be around for the morning.
I think that's doable. I just can't, and I'm sorry, I just can't do it now.
That will all depend if district court is done, because district court starts at 10:30 and they use the Polycom, Your Honor.
Got it. All right. Well, I suppose if need be, we can do Mr. Schultz, if he doesn't mind, by telephone. We did that on the last one with the fingerprint form brought in. Is that okay if need be?
Yes, sir. That's perfectly
Mr.
fine.
Schultz, is that okay? Okay.
Right. So why don't we try to do that after Stubblefield then, and I'm going to have to run right now because it's 9:59. So I'm sorry, but we'll make it work. Thank you.
Note to have you.
Okay.
Hey, Richard, did he say 10:30 then, or did he say 11?
He said 11 o'clock, Nick.
Okay, thanks. Russell, did you get that? You're going to be on the phone at 11?
Yes, I did. Thank you, sir.
All right. We'll
Is that
talk to you
okay
then.
with you, Peter Carlson?
Yeah, that'll work. I'll be there.
Thank you.
Thank you.
The chairperson has